Good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on defenses in criminal law. The video content has been made available for informational and educational purposes only. Kindly go through this page completely. Let's start with the problem question. Chris is having a peaceful morning walk when he is attacked by a stray dog. While trying to protect himself from the dog, he waves his arms in panic and hits Addie, a passerby. Addie suffers a broken nose. Joes, another passerby, comes to help Addie and bends over to check on him. Addie's girlfriend, Chidi, on arriving at the scene, thinks that Joes is attacking Addie and hits Joes on the head with a rock she found lying nearby. Joes suffered a fractured skull. In the meantime, Chris chases the dog away and walk off. Chris is a diabetic, but due to the trauma of the dog attack, he forgets to take his insulin. He walks to work feeling increasingly confused, succumb to hyperglycemia. Hyperglycemia. Mosen, a colleague, notices that Chris is looking unwell. Moisen goes over to him and asks Chris if he is all right. Chris, in his confusion, thinks Mosin is about to attack him and so punches him in the stomach. Discuss. We have to discuss if Chris and Chidi have any defenses available, and we need not to discuss any offenses. Would it make any differences? This is an alternative scenario. Would it make any difference to our answer if the reason for the Chris confusion when he punched Mosen was caused by voluntary intoxication? Let's analyze each and every scenario in detail. The first one, we will start with Chris and the attack on Addie. Chris may argue automatism as a defense for hitting Addie. Automatism requires that a defendant's action were involuntary due to an external factor as established in Hill versus Baxter in 1958 and Bratty versus Attorney General of Northern Ireland case in 1963. A Chris involuntary waving of his arms in response to the stray dog attack can be characterized as an external factor causing an automatic reaction. To succeed, Chris must show that his action were entirely outside his control. However, the involuntariness of his action could be questioned if it is deemed that Chris had a partial control and who could have acted differently. For example, if the court finds that Chris' action were a disproportionate or unreasonable response to the situation, the defense of automatism may fail. Given the circumstances, the dog attack was sudden and unexpected. The Chris action appeared to fall within the definition of automatism, as his response was likely reflexive and involuntary. Alternatively, the Chris defense for hitting the Addy could rely on automatism. The automatism negates the liability when the defendant action are involuntary and caused by an external factor as established in Hill versus Baxter. Here, the straight back attack created a situation where Chris acted involuntarily, waving his arm in the panic to protect himself. This aligned with the principle in Bratty versus AG for the Northern Ireland in 1963 case, where the involuntary action due to the external stimuli were deemed non-culpable. A Chris action were not willed, but were a direct response to the external threat posed by the dog. For automatism to succeed, it must be shown that Krish had no control over his actions and that they were not self induced. Unlike Orr versus Quick in 1973, where the difference hypoglycemia was self induced by failing to eat, the Chris reaction here stems directly from an external threat, that is, the dog attack. Therefore, he may successfully argue automatism as his contact was not deliberate and was provoked by an external factor. Let's analyze the second scenario where Chidi and the attack on Joes. A Chidi may argue a self defense or the defense of another for her action against Joes. Section 76 of the Criminal Justice and Immigration Act 2008 provides that a person may use a reasonable force to defend themselves or another provided they genuinely believe it is necessary. In Orr versus William Gladstone case in 1984, the court held that the defendant's belief in the necessity of force need not be reasonable as long as it is genuine. Here, Chidi believed Jose was attacking Ade, her boyfriend, which motivated her to strike him with a rock. While her belief may have been genuine, the force used, a blow to the head with a rock, raises question about proportionality. Under the Palmer versus Orr case 1971, the force must be reasonable in the circumstances as the defendant believed them to be. Hitting the jaws with a rock causing a fractured skull could be considered excessive, especially as Jaws was merely checking on Addie. Consequently, while Chidi may succeed in showing she acted in the defense of another, her action could be deemed disproportionate, limiting the availability of this defense. In other words, Chitty could argue the self defense under the Section 76 of the Criminal Justice and Immigration Act 2008. Self defense allows the use of the reasonable force to protect oneself or another, provided the defendant honestly believe it is necessary. In Orr versus William case in 1987, the court held that a mistaken belief in the need to defend someone can still justify the use of force as long as the belief is genuine. Here, the Chidi mistakenly thought Jose was attacking Addy and acted to protect him. The proportionality of Chidi's response must also be evaluated. Under Section 76.6 of CJIA, the force used must not be disproportionate to the perceived threat. Striking Joes with a rock causing a fractured skull could be viewed as an excessive, particularly since Joes posed no actual threat. This differentiates the case from R versus Palmer in 1971 case where the force used was deemed reasonable given the circumstances. If Chidi's response is found to be disproportionate, her defense may fail. However, the fact that Chidi acted in the heat of the moment, influenced by her belief in the need to protect Addie, may weigh in her favor. Let's move on to the third scenario where Krish and the attack on Mosen. For punching Mosen, Krish may argue the insane automatism, as his action resulted from hyperglycemia caused by his failure to take insulin. Under the M. Nathan's rule, a defendant can claim insanity if they were suffering from defect of reason caused by a disease of the mind such that they did not know the nature or the wrongness of their action. In R versus Henry in 1989 case, the hyperglycemia due to the diabetes was classified as a disease of the mind for the purpose of insanity. And the Chris confusion and the misperception of the motion as an attacker indicate a defect of the reason. However, the insanity defense carries a significant consequences, including the potential for the hospital order, which Chris may seek to avoid. Alternatively, Chris could argue automatism if his hyperglycemia is viewed as a caused by an external factor. For example, a trauma from the dog attack. That it's distinguishing it from Henry case. Nonetheless, this argument may be weaker as a hyperglycemia is typically classified as an internal condition. In other words, a Chris confusion and subsequent attack on Mosen raises the question of insanity or automatism. Depending on the cause of his state, under the Macton's rule, insanity requires proof of a defect of reasons caused by the disease of the mind, such that the defendant either does not understand the nature of their act or does not know it is wrong. Chris' hyperglycemia resulting from his failure to take the insulin constitute an internal cause akin to R versus Hense case in 1989, where a diabetic episode was classified as insanity due to its internal origin. However, if Chris' confusion is seen as triggered by the external trauma of the dog attack, the situation may resemble quake where the hyperglycemia induced by the external factor was treated as automatism rather than insanity. If the court determines that Chris' confusion stemmed from his debates from the diabetes rather than the dog attack, the defense of insanity would apply, and the M. Norton's rule would govern. If the dog attack is deemed the primary cause, he may argue automatism. Both the defenses turn on whether the Chris action were voluntary and whether he retained the capacity to understand his action. Let's analyze the losses scenario, the alternative scenario. If Chris' confusion when he punched motion was caused by a voluntary intoxication, his defense would likely fail. The intoxication can only negate the liability for the crimes of specific intent as established in DPP versus Medwick case in 1977. Assault is a crime of basic intent, and the voluntary intoxication does not excuse such conduct. Even if Chris lacked the intent due to intoxication, his reckless decision to consume substances would substitute for the mens rea required for the offense. Thus, the voluntary intoxication offers no viable defense for the assault on Mosen. In other words, if the Chris confusion were caused by voluntary intoxication, the defense of automatism would not apply as held in R versus Lipman in 1970. The voluntary intoxication may negate a specific intent offenses but not basic intent offenses as established in DPP versus Medwick case in 1977. Therefore, a Chris would likely be unable to rely on intoxication as a defense, leaving him liable for his actions. To conclude, Chris has a strong automatism defense for hitting Addy as his actions were likely involuntary due to the external factor on the dog attack. For punching motion, the Chris may rely on the defense of insanity as his confusion resulted from hyperglycemia, a disease of the mind under Henze. However, if his confusion was caused by voluntary intoxication, he would be unable to rely on automatism or the insanity. Chidi may claim a self defense or defense of another for hitting Joes, but the disproportionate use of force with a rock makes the success of the defense uncertain. Both the defendant liability depend on the court evaluation of their respective circumstances and reasonableness of their responses. Thank you. Further, Chitty may argue the self defense under the section 76 of CJIA, but her response appears disproportionate, potentially undermining her defense. These defenses are nuanced and turn on the factual interpretation of the events and the proportionality of the responses. For example, Chris can likely rely on the automatism for the attack on Ari as his actions were involuntary and provoked by the external threat of the dog attack. For the assault on motion, whether he can claim insanity or automatism, it all depends on whether his confusion is attributed to his diabetic, that is internal cause, or the dog attack, that is external cause. In the alternative scenario involving the voluntary intoxication, the Chris defense would fail as intoxication could not negate the liability for the basic intent crimes. Thank you.